So let me get this straight. On Sunday, August 24th, 1924, Helen Palsgraf waited on the Long Island Railroad platform at East New York Station on Atlantic Avenue in Brooklyn. She waited patiently when another train pulled in and stopped. When the train started moving again, a man with a package ran and jumped for the train. A crew member pulling him and a platform guard pushing him, he was helped aboard. In the process, the passenger's package fell onto the tracks and exploded. The package contained fireworks, which are probably legal. I mean, it's the 1920s. Coca-Cola still has some cocaine in it. Anyways, either the force of the explosion or the panic of the waiting passengers caused a large scale to fall onto Helen. Multiple people were listed as injured, but no one spent the night in the hospital. Helen's injuries were bruises and shock, and she's also developed a stutter.
Yes, Your Honor.
This case has reached the highest court in the state, and yet no one has bothered to identify the man carrying the explosives or the distance between the plaintiff and the actual explosion.
Well, the scale was more than 10 feet away from the explosion, and the man was Italian.
Of course he was. It's Brooklyn. As this is a matter of New York case law, you must show that the Long Island Railroad Company had a duty of care and that Helen was injured through a breach of that duty. You do not need to prove that the duty was owed directly to Helen.
Your Honor, the typical duty of care of the common carrier like the railroad does not apply to the platform, just the train, under New York precedent, that is.
Oh, word?
Word, Your Honor.
Go.
So, Team Paulsgraf, you originally brought this before the Supreme Court of New York, which is actually a trial level court in this state only, which just adds to the confusion in all this. At the trial, you testified that the scale hit Helen in the side, that she was treated and then taken home in a taxi. She had some trembling for a few days and then the stuttering began. Wood, you called a witness to the stand where he stated that the scale was blown right into pieces?
Correct. I then called Helen's physician where he testified that he treated Helen occasionally for minor ailments prior to the incident, and that she was shaken and bruised on the day after the incident. Her doctor claimed that her injuries were in fact caused by the accident. I called a neurologist to the stand as well. They examined Paulsgraf 2 days before the trial and diagnosed her with traumatic hysteria, noting that the explosion as the cause and the illness would likely continue until the trial's end.
The Long Island Railroad Company moved to dismiss the case twice due to a lack of evidence and were denied both times. As it is the 1920s, you had an all-male jury, and Judge Humphrey told that jury that if the railroad employees omitted to do the things which prudent and careful trainmen do for the safety of those who are standing upon the platform waiting for other trains, and that the failure resulted in the plaintiff's injuries, then the defendant would be liable. Railroad, you appeal.
Yes, Your Honor. We brought the case before the Appellate Division of New York Supreme Court. We contained the original verdict went against the law and the evidence. The railroad employees had no knowledge that the package was dangerous, and there was no law that requires them to search the passenger's luggage. There was no negligence in helping the man make the train. And even if there was, it was not the proximate cause of Paulsgraf's injuries.
Wood, you stated that the appellate court should not question the jury's verdict in which they found negligence through undisputed facts.
Correct. I also noted how the railroad did not use the railroad employees as witnesses. Those men were guilty of the misconduct that caused Helen's injuries. The judge there ruled that the jury's decision of negligence was supported by the evidence. The judge assumed that the jury believed that helping a passenger board a moving train was a negligent act. The judge claimed the case was no different in principle from the well-known court case decisions on causation.
The appellate division focused heavily on the duty of care that the railroad owed to Paulsgraf and agreed with the original verdict 3-2. However, a presiding judge wrote a dissent, which is what entitled you to bring the case here. The dissent stated that the employee's conduct was not the proximate cause of Paulsgraf's injuries, since the man bringing an explosive package to a crowded passenger station was an independent act of negligence, meaning the neglect by the railroad was too isolated in causation for there to be liability.
Your Honor, the plaintiff failed to prove that she was harmed through railroad negligence. The action of the railroad employees did not harm Paulsgraf. Her injuries were not a natural, probable consequence of assisting a man boarding a train.
Go on.
The railroad employees could not have stopped the man from boarding. The man jumped for a moving train. What are they supposed to do? shove him onto the tracks. The trainman had no choice but to help him. When facing an emergency like this, one cannot be charged with negligence since they elected to assist the man rather than stand by and leave him to his fate.
Your closing statement, Paulsgraf?
Your Honor, negligence was found by the jury and by both majority and dissenting judges in the appellate division. There was also negligence in the train's failure to shut its doors as it departed. You have failed to acknowledge the plaintiff as a paying customer and instead have belittled her as just a bystander, thus eliminating the duty of care owed to her. Do you have no soul?
The conduct of the railroad employees, if a wrong in its relation to the holder of the package, was not a wrong in its relation to the plaintiff. Relative to Paulsgraf, it was not negligence at all. Only if there is a duty to the injured plaintiff, the breach of which causes injury, can there be liability. If a railway guard stumbles over a bundle of newspapers and there are explosives within, will there be a liability to an injured passenger at the other end of the platform? Would the result be different if the object containing the explosives was a suitcase instead? If there was negligence that day, it was only negligence that resulted in the fall and destruction of the package, and there was no wrong done by the railroad to Palsgraf for personal injury. The risk reasonably to be perceived defines the duty to be obeyed. Even if the railway guard had thrown down the package intentionally, not knowing the contents, he could not knowingly risk harm to Paulsgraf and would not be liable. Negligence cannot impose liability where an intentional act would not. Negligence derives from human relations. Negligence that does no one harm is not a tort. It is not enough to prove negligence by the defendant and damage to the plaintiff. There must be a breach of duty owed to the plaintiff by the defendant. Had the railroad been negligent towards Paulsgraf, it might have been liable, but the consequences to be followed must first be rooted in a wrong, and there was no legal wrong done by the railroad to Paulsgraf. The court reverses the appellate judgment and rules 4-3 in favor of the defendant, Long Island Railroad Company. The lower courts were incorrect and must be reversed, and the case must be dismissed. Paulsgraf will pay the costs. Court is adjourned.